Welcome to Deep Dive. Today, we're taking a deep dive into something really significant. It's a subject that could reshape the futures of, well, thousands of international students, exchange visitors, maybe even foreign media reps who want to study or work here in the United States. We've looked closely at the latest government proposals and expert takes to bring you the critical insights on what's happening. At its heart, we're discussing a proposed regulation, and it aims to fundamentally change how long certain non-immigrants, those in FJ and I visa categories, can actually stay in the U.S. Right now, many of them are here for what's called the duration of status, which basically means they can stay as long as they follow the rules of their visa. Pretty flexible, but these new proposals, they could bring in fixed end dates. That's a huge shift from how things have worked for decades.
It really is. And what's fascinating, or maybe concerning, depending on your view, is that if this proposal actually becomes a final rule, it would be the biggest shakeup to how we regulate international students and scholars in, well, 20 years. This isn't just some technical tweak to visa rules. I mean, it raises a whole cascade of questions about what it means for individuals, for universities, colleges, and, yeah, critically, for the U.S. economy itself. We're here to help you understand not just what they're proposing, but maybe more importantly, why it matters so much.
Okay, right. Let's unpack this. Let's start with the current system, just so we're all clear, and then really dig into how big this proposed change is. Because if you're, say, an international student starting a PhD that might take 6, maybe 7 years, or a journalist assigned here, these changes could completely upend your plans.
Precisely. So, under the current system, specifically for F1 students and J1 exchange visitors, their stay is governed by this duration of status, or DS. It means they're allowed to be here as long as they're complying with their visa terms, making progress in their program or activity. There's no hard stop date tied to their initial admission as long as everything's in order. And this has been the standard practice since 1991 for F students and 93 for J visitors. It ties their stay to actually finishing their program. It offers, well, a degree of flexibility.
And now that flexibility is basically on the chopping block. The Department of Homeland Security, DHS, they floated this idea first back on September 25, 2020. The idea was to put fixed end dates on F, J, and I visas. That version got pulled back, but a revived proposal just cleared White House review very recently, August 7, 2025, which tells us the government seems pretty serious about moving this forward now.
That's right. The general concept is to limit someone's stay to the program end date that's on their Form I-20 if they're a student, or their DS 2019 for exchange visitors. But here's the really crucial part. That period generally wouldn't be allowed to exceed 4 years.
A 4-year cap. So a hard limit, potentially cutting short programs that naturally take longer. Now, DHS has given its reasons for this. They're citing national security risks, potential for fraud. They say it would give them greater oversight, protect the integrity of the programs, allow them to detect security concerns more quickly. But what's interesting is that DHS itself in the proposal acknowledges this might actually lead to fewer international students enrolling. It almost sounds like they're anticipating a trade-off. Maybe less talent, but more perceived security.
That's exactly the tension here. You've hit it. While DHS points to national security and fraud, critics point out that a lot of the information DHS says it needs. Things like a student's country of origin, if they've dropped out of status, if they're changing education levels, that's already reported systematically. It's done through SOVIS, the Student Exchange Visitor Information System. So it raises a really important question. How much more oversight would these new rules actually provide compared to what's already in place? And are the changes maybe disproportionate to the problems they're trying to solve?
Okay, and this is where it gets really interesting, like you said, because these fixed periods, they aren't the same for everyone. Most might face that 4-year cap, but some groups could be limited to just 2 years for their initial visa term. That's a big difference. Can you walk us through who falls into that 2-year category?
Absolutely. It's quite specific. The 2-year limit would apply first to individuals born in or citizens of countries designated as state sponsors of terrorism. Currently, that's Iran, North Korea, Sudan, and Syria. It also applies to citizens in countries where the visa overstay rate for students and exchange visitors is over 10%. And DHS has listed a very broad range of countries here, predominantly from Africa. Think Benin, Burkina Faso, Burundi, Cameroon, Chad, Ethiopia, Ghana, Kenya, Nigeria, Mali, Niger, Somalia, Uganda, Zambia, just to name some. And from Asia, too.
Yeah.
Afghanistan, Bhutan, Burma, Nepal, the Philippines, Tajikistan, Uzbekistan, Vietnam.
Wow. That's a really extensive list. It makes the proposal feel much broader in its potential impact. Are there other situations where the 2-year limit kicks in, maybe based on the school itself?
Yes, there are. Non-citizens who aren't attending institutions accredited by an agency recognized by the Secretary of Education, they'd also face the 2-year limit. Same goes for students at schools or in exchange programs that aren't fully participating in E-Verify, the federal system for checking work eligibility. And then there's a kind of catch-all. The DHS secretary could decide that U.S. national interests warrant a 2-year maximum in other specific cases. It gives them a lot of discretion.
So even if you're not from one of those listed countries or your program is definitely longer than 2 years, you could still get hit with that shorter limit based on your school status or maybe just a general determination. That creates a ton of uncertainty for planning. What about students just coming for English language training? Is there a cap for them?
Yes. For F1 students specifically doing English language training, they'd be limited to a maximum of 2 years total. And that includes any breaks or vacations they take. And another thing, students who finish a program at one educational level, say a bachelor's, they'd be limited in changing to another program at that same level, no more than 2 additional times. So imagine an undergrad wanting to pursue a second bachelor's in a totally different field. This rule could potentially stop that kind of academic exploration.
That sounds like a real hurdle, especially for students trying to figure out their path or just get the language skills they need first, which leads to a big question. If these changes happen, how would a student actually get an extension? And what reasons would even count?
Yeah, it would be a fundamentally different process. Under this proposal, students wouldn't just get a recommendation from their designated school official, their DSO. That wouldn't be enough anymore. They'd also have to proactively apply for an extension directly with USCIS, that's U.S. Citizenship and Immigration Services. They'd file a specific form, the I-539, and critically, they'd have to do it before their current admission period expires. And here's a kicker. Biometrics would be collected for every single extension application.
Biometrics every time. Wow. Think about the added cost, the time involved, the appointments for potentially multiple extensions over a long program.
Exactly. It adds a whole new layer of complexity, cost, and likely bureaucratic waiting.
So, okay, if a student goes through all that, what grounds would USCIS actually approve an extension on? Because if the criteria are super strict.
They are quite specific. Extensions could be approved if the program, genuinely takes longer than the initial period granted. Or if there's a compelling academic reason. The classic example is a PhD program. They often take 6, 7, 8 years. That would clearly need extensions beyond the initial 4 years. Also, a documented medical illness or condition could work, or other circumstances that are truly beyond the student's control. But here's the crucial detail. Just failing classes or facing academic challenges. That would not generally be a basis for extension anymore. USCIS seems to view that as something within the student's control, so less room for academic recovery, perhaps.
So a much tougher standard, more burden on the student to prove their case. What about international students who are already here, studying right now under the current duration of status? How does this hit them?
Right, that's a key question. For F and J, non-immigrants who are currently here and maintaining their status properly, they'd generally be authorized to stay until the end date listed on their current Form I-20 or DS 2019. However, that period couldn't go beyond 4 years from whenever the final rule actually takes effect, plus a grace period. So if they need more time after that, maybe to finish their current studies, or for OPT or STEM OPT after graduation, or maybe to start a new degree, they would have to apply for that extension of stay we just discussed. Think about someone maybe in their 5th year of a PhD right now. They thought they were fine under DS, but suddenly they need to file an I-539.
And speaking of OPT optional practical training that's so vital for many students to get U.S. work experience, what specific changes are proposed for that whole process?
There are several key changes there. First, the grace period after studies finish the time students have to stay, maybe find a job, apply for OPT, or leave would shrink from 60 days down to 30 days.
Half the time. Wow.
Yeah, puts a lot more pressure on those post-graduation plans. The window to apply for OPT work authorization also shifts. You'd have more time before your program ends up to 120 days instead of 90, but less time after only 30 days instead of 60. So you need to be much more proactive. Interestingly, the rule drops the requirement that you have to file within 30 days of your DSO recommending OPT. A small bit of flexibility there. And one positive tweak. The OPT gap, that's the automatic extension for students caught in the H-1B lottery wait, would extend longer, from October 1st potentially to April 1st of the next year. That acknowledges the H-1B timeline realities a bit better.
Okay, so shifts in the timing, a shorter grace period, but there's a really critical procedural point about OPT too, isn't there? Something that could cause big problems.
Yes, absolutely critical. Under the proposal, students wanting post-completion OPT would have to apply for 2 things separately. First, the extension of stay, EOS, to cover their time during OPT. Second, the Employment Authorization Document, EAD, the actual work permit. These would be separate applications, likely with separate processing times, and crucially, you couldn't start working until the EAD is approved, even if your EOS extension comes through first.
Oh, I see. So you could have your legal status extended, have a job offer waiting, but be stuck, unable to work for months while the EAD application grinds through the system.
Precisely. That could lead to real financial hardship, lost job opportunities, a huge amount of uncertainty right when graduates are trying to launch their careers.
Yeah, if we connect all these dots, you can really see how this proposed change isn't just a small administrative tweak. It touches everything from an individual student's life birth to, well, the financial health of universities and maybe even the whole U.S. economy.
Exactly. It makes you step back and consider the bigger picture, the global ramifications.
Which is probably why we're seeing such strong reactions from universities and advocacy groups.
Absolutely. Higher education institutions and key organizations like the President's Alliance on Higher Education and Immigration, NAFSA, Association of International Educators, the American Council on Education, they're strongly opposing these changes. They see this proposal as fundamentally undermining the value and viability of international education in the United States.
And their concerns seem pretty concrete, especially around those procedural burdens and the potential for just massive delays, right? It sounds like USCIS could get completely swamped.
That's a huge worry. The new extension process, with the I-539 and biometrics for potentially hundreds of thousands of people, it's seen as incredibly burdensome and costly. Costly for students, obviously, with fees and travel for biometrics, but also costly for institutions that would have to dedicate more resources to support these applications. And yes, there are major concerns about whether USCIS even has the capacity to handle this potential flood of new applications, given their existing backlogs, especially with things like OPT. Plus, there's uncertainty about how long extensions would even be granted for. Would it be just month to month, a year at a time? And critically, if your extension gets denied, it might not even be appealable. That leaves students with very few options.
Beyond just the logistical nightmare, there are these deeper worries about academic freedom, about students actually being able to finish their programs.
Yeah.
How do these fixed timelines clash with the reality of academic life?
Well, these sort of arbitrary timelines, like a 4-year max for many, they just don't really map onto how academic programs actually work in the real world. I mean, the average bachelor's degree in the US, it takes closer to 4.5 years, not 4 on the dot. And PhDs routinely require 6, 7, 8 years or more. Imagine being a PhD student, deep into complex research, and suddenly facing this artificial deadline. It could really limit a student's ability to maybe change majors if their interests evolve, or explore different research avenues, or just take the time needed for rigorous scholarship. Ultimately, critics worry it will actively discourage international students from even starting longer programs here, especially research-focused ones. They might just choose to go elsewhere.
And the economic fallout could be really substantial, couldn't it? This isn't just about campus life, it hits the economy.
Oh, massively so. International students contribute something like $41 billion to the U.S. economy every year. They support over 450,000 jobs. These are big numbers. Some projections suggest this rule change could lead to a 30, maybe 40% drop in new international enrollment. That could translate to a potential $7 billion hit to the U.S. economy annually. And that's not just an abstract number. It would seriously impact college budgets, especially smaller regional schools that often rely heavily on international student tuition. Some analysts are even warning that without international students and immigrants, some U.S. colleges could actually face closure. It's a vital financial stream for them.
So the worry is this could actively push top global talent away from the U.S., making us less competitive internationally.
That's a profound concern, yes. Advocates argue these rules create so many barriers, so much uncertainty, that they just make the U.S. look like a less attractive, less welcoming place compared to other countries. Countries like the U.K., Canada, Australia. They're often seen as actively trying to recruit the talent we might be pushing away. And in the long run, that could really weaken the pipeline of talent into the U.S. workforce, especially in critical STEM fields. It could stifle innovation, diminish our global competitiveness. If the best minds choose to go elsewhere, we all lose out.
We talked about the DHS rationale, national security, fraud prevention, but you mentioned earlier a lot of the tracking data seems to already exist in SEVIS.
Many critics argue exactly that point. They suggest SEVIS already provides a pretty robust system for tracking students and exchange visitors, giving DHS real-time data. The argument is that the existing system, if maybe used more effectively or enforced differently, already offers many of the safeguards DHS claims these new rules are needed for. So there's a real debate about whether these new burdensome measures are the most effective way to address those concerns, or if the cost in terms of complexity, deterrence, and economic impact outweighs the potential benefits.
And this isn't happening in isolation, is it? There are other immigration policy shifts being proposed or happening that paint a broader picture.
That's true. There's also that separate DHS proposal for H-1B visas, the main work visa for skilled professionals. That proposal would ditch the random lottery and move to a system prioritizing higher salaries, which could make it harder for recent international graduates to get an H-1B, even if they have a job offer. And it's worth remembering some past actions, things like temporary status verifications, talk of enhanced social media screening under previous administrations. They've already created a kind of unsettled feeling among international students. These new proposals, they don't exist in a vacuum. They add to a perception, rightly or wrongly, that the U.S. is becoming a harder place for international students and scholars.
So wrapping our heads around all this, what does it really mean for you, the listener, whether you're thinking about studying internationally, maybe you're already a student here, or perhaps you're just interested in immigration policy and how it affects the country? It really means that staying informed, paying attention to these ongoing discussions, and the whole regulatory process is absolutely key, because these changes, if they happen, could truly reshape the landscape of international education in the U.S. for years, maybe decades to come. So as we've really unpacked today, this proposed regulation to shift international student and exchange visitor visas away from duration of status to fixed end dates, it's a genuinely significant development. The implications are just wide-ranging. From those specific limits on stay, that tough 2-year cap for certain groups, to the whole new, complex, and potentially slow extension process. And then factoring in the serious concerns from universities about enrollment, about the economy, it's a really complex issue affecting so many people and vital parts of our society.
And it really brings us back to that fundamental question, doesn't it? How do these proposed changes genuinely balance the stated goals of national security with the, frankly, invaluable contributions that international students and scholars bring to our communities, our economy, our global standing? It's a critical conversation, and it's one that's definitely going to continue as we wait for the proposal to be published and the public comment period to open up.
We really hope this deep dive has helped you get a quicker, clearer grasp of the crucial details surrounding this proposed rule. All the best, and we will meet again with another important subject in the next meeting.